The Rebel Capitalist Show. When we're thinking about the principles of how the law should be set up, what are just kind of the basics? Let's start from that. So we have to have private property rights. But when people talk about rule of law, do we need to really, the basics should be that as long as I'm not infringing on your private property and your body or your well-being would be that private property, then it shouldn't really be a law. Can we start with that, or am I being way too simplistic?
No, we can start with that. You have just articulated the Rothbardian, as in Murray Rothbard, non-aggression principle. All aggression, whether physical or by some means of deception against the person or property, is illicit. Then the question becomes, what power does the government have? Jefferson said the linchpin of government power in a free society is the consent of the governed. So I would say to my constitutional law students, is there anybody here who has consented to the Constitution? Well, the answer is no. The Constitution was consented to by about 35% of adult white landowning males in 1789 when it was ratified by the 13 states. If you haven't consented to the government, then government is illicit. Question: can a government do anything morally in the absence of consent? Answer: yes. It can enforce your natural rights. It can stop somebody from interfering with your person and your property, and it can stop you from interfering with someone else's person and property, but it can't do anything else without consent. This is all theoretical. The government's not going to go away tomorrow.
Right.
But when government does something without the consent of the governed, according to Jefferson, it is the time to alter and abolish it. That's not me, that's the Declaration of Independence, the first statute enacted by Congress. So when members of Congress take an oath to the Constitution and the laws of the land, they're including the Declaration of Independence. When the government fails to protect liberty, actively assaults liberty, or no longer has the consent of the governed, it is, quote, the duty of the governed to alter or abolish it, close quote. Thomas Jefferson and the Declaration of Independence. So rule of law, non-aggression principle, consent of the governed. That's basically the government that existed after we won the revolution and before the Constitution, which commenced big government, before the Constitution was ratified. You know, I've spent my career defending, explaining, and when I was on the bench, interpreting the Constitution. I've come to the conclusion that functionally it has been a disaster. It has absolutely failed to restrain the government. Formally, it still exists. We still take oaths to it. The format of the government that it created is still there. So formally, it exists. Functionally, it's been a failure. I don't think I would have voted if I were around then and knew then what I know now, to have ratified the Constitution. The objectors to the Constitution, George Mason and the anti-federalists, even Jefferson himself, though he was relatively silent about it at the time, in his writings he objected, were worried about 3 or 4 things. They were worried about wars without end. They were worried about obliterating the sovereignty of the states. They were worried that the central government's new bank, its own bank, would regulate economic activities. And they were worried that the central government would crush civil liberties. All 4 of their fears have come to pass.
Didn't Madison write about that? The report of 1800 is what I'm specifically referencing, because people, like to believe that the Supreme Court is there to, make sure that the legislative branch or the executive branch is behaving by the rules of the Constitution, but they can be corrupted. And the result is what you just pointed out. that the Constitution in and of itself is null and void. But I believe Madison wrote in that report in 1800 that he believed that the states really had the final say so.
All right, so
go ahead.
I think you might be referring to the Kentucky and Virginia resolutions. Kentucky resolution written by Madison secretly at the time, Virginia resolution written by Jefferson secretly at the time in reaction to the Alien and Sedition Acts. Okay, brief history. The First Amendment says Congress shall make no law abridging the freedom of speech. During the Adams administration, the Federalists enacted the Alien and Sedition Acts, which, among other things, made it a crime to be critical of the government. Madison was in the House of Representatives at the time, fiercely opposed the Alien and Sedition Acts, secretly wrote in the Kentucky resolutions a statute enacted by the Legislature of Kentucky. Jefferson in the Virginia resolutions, a statute enacted by the state of Virginia, saying that the federal Supreme Court is no serious check on the Congress, that only the highest court or the legislature of a state is the check on the Congress. And since the states did not give away the power when they formed the federal government to correct the federal government, they still have that power. That's known as nullification. So the Virginia resolution declared the Alien and Sedition Acts null and void in Virginia. The Kentucky resolution declared the Alien and Sedition Acts null and void in Kentucky. George, in a midnight cryptic decision, the Supreme Court of the United States revived nullification. When the state of Texas nullified Roe versus Wade and said abortions are unlawful after 6 weeks in Texas, not after 24 weeks. And the Supreme Court refused to disturb that. It basically said Texas has the authority to do this. If nullification can come back, we can stop big government Leviathan in its tracks. Whether it's the Democrats controlling the Congress or the Republicans controlling the Congress. The Republicans did as much shenanigans in the Bush years as the Democrats have done in the Obama years. It's just a different version of big government. It still saps our liberty and saps our property by taking wealth from us.
Yeah, and Tom Woods made a great point as well on the topic when he pointed out the marijuana legalization by the states.
Well, marijuana legalization, first of all, Tom Woods, a dear friend of both of ours, is the guru in the case, not a lawyer, but he knows more law than a lot of lawyers that practice before me. He is the guru on nullification in the country. So I bow to Tom, and of course we agree on all this, but he's right. You know, when you nullify an unpopular law, like the marijuana laws, the feds will look the other way. When you nullify a law that the big government people really like Roe versus Wade, they're not going to look the other way, and they're going to do everything they can to try and defeat nullification. But the Texas legislature, George, may have unwittingly lit a brush fire of freedom by the way it wrote that statute and the Supreme Court's refusal to dislodge the statute during the pendency of the challenge. Now, the abortion providers in Texas will still have their day in court. Whoever wins will appeal it to the Fifth Circuit. Whoever wins will appeal it to the Supreme Court. So it'll be back to the Supreme Court. But by denying the preliminary injunction, the Supreme Court is making a value judgment and saying, first of all, you're probably not going to win, abortion providers, because if you were, we would grant this preliminary injunction. And secondly, the legislature that you're challenging has the authority to do this. By saying those two things without using the word nullification, they have revived the concept of nullification here in 2021.
And that's something to be excited about.
If they stick with this, there'll be a sea change in constitutional jurisprudence. And we small government people will be shouting from the rooftops.
Yeah, that's a huge victory. That's for sure.